Thanks, Jonathan. It's always great to work with Cooper Square Committee and with all of the tenants who've been organizing and fighting for a long time to keep the Lower East Side and the East Village affordable and a diverse community. So thank you all, and I'm glad to see some familiar names here. I am Mike Grinthal. I am the Director of Housing at TakeRoot Justice. I'm a housing lawyer, and I've been a housing lawyer in New York City since 2007. Um, and before we get started, if folks are able, I'd love it if people could put in the chat um, either what your building is or who your landlord is, if you're comfortable sharing that, just so that we can see where we're all coming from. And give me one moment. I'm just going to get the slideshow started. Okay, so folks should be seeing the screen now that says the right to protest. Jonathan's nodding yes, so it looks like that's working. All right, so tonight we are going to be talking about the various laws and rules that impact how we protest and what kinds of risks we take if we protest in different ways, and what to make of and how to respond to threats from landlords or others saying that we're trespassing or that we're doing something illegal. Um, So I just want to quickly say TakeRoot Justice, the organization I work for, we're a nonprofit legal services provider, and we provide legal and research and policy support for groups like Cooper Square Committee and tenant associations that are organizing at the grassroots to preserve housing, preserve community, and dismantle racial, economic, and social oppression. Today, we are going to start off with an icebreaker, and then we're going to talk about what we mean by action in organizing. Then we're going to look at the laws that affect actions in public spaces and the laws affecting actions on private property. And then we're going to finish up talking a bit about the laws in New York that protect tenants' right to organize. And we'll have a question and answer session at the end. If you have a clarifying question or something that I say isn't clear and you need me to speak a bit more on it, you can put your hand up or put something in the chat. I'll ask Anna and Jonathan if they could keep one eye on the chat. Thanks. Otherwise, we will be able to get into discussion at the end. Before we get started, though, I wanted to just say something about what it means that we're going to be talking about these laws, right? So I'm a lawyer. It means that I can talk a lot about what's legal and what's illegal and what the law says you should do and what the law says you shouldn't do. But what is legal or illegal is not the same thing as what's right or necessary for people to do, right? People who are organizing may choose to break the law, to do civil disobedience, to not follow unjust laws as an act of conscience, or people may have to break laws just as, as a means of survival. And so throughout this training, I may sometimes say things like, you can do this, you can't do that. I'm going to try not to use that language, but if I do, um, please hear that as this is what the law says, not what it's right for you to do or not do. You and the people that you're organizing with are the only people who can decide what's right and wrong for you. The goal of this workshop is just to make sure that you have the legal tools to make informed decisions so that if you do break a law or take a risk, you're doing it on purpose and not by accident. All right. So let's get started with a little bit of icebreaker. Since folks' cameras are off, I'm going to change the instructions here. Turn on your camera if you agree with or have experienced the following situation. Your landlord has told you you're the only one complaining. You can turn on your camera or raise your hand. No? Also recognizing some people might not be on a device where they can do that. All right. Well, how about this one? Turn on your camera or put up a hand or put something in the chat if your landlord didn't show for a repair appointment. Oh, okay. How about if you feel your landlord has intentionally mismanaged your building or done something to pressure you to move out? Okay. And again, if the device you're on either doesn't allow you to put on your camera, where you are doesn't allow you to put on your camera, you can respond any way that works for you, whether that's putting something in chat, putting an emoji up, or turning your camera on. I'd be really interested to hear if folks have already successfully protested against their landlords. Okay. And has anybody had the experience of the police or the landlord's employees showing up at a housing action? All right. So we're going to talk about actions. We're talking about the laws that govern actions here. And just to make sure that we're all on the same page with what an action is, and an action is something that people do together. It's a collective way to resist injustice. So it could be a protest, it could be a direct action, a sit-in, a march, a rent strike. It could be testifying at a hearing, it could be a press conference. There really is no limit to what an action can look like, except that it is something that we do together with the power in numbers so that we can uh, exercise our power together for justice. All right. So more specifically, an action is a planned, organized event with clear goals that attempts to hold a bad actor accountable. It's a public demonstration of unity and power. And as we said, it could take many forms, press conference, rally, march, protests, again, only limited by our imaginations. It can be large, it can be small, it can be in many different places. It can have many different goals to bring people together, to get the attention of media, or just to speak truth to power. Okay, so now we're going to get into what the law says, what laws affect how we do our actions. And so first we're looking at actions that take place in public spaces. So that would include sidewalks, streets, parks, plazas, squares, um, government buildings. All right. So let's start with the First Amendment, right? Aside from whatever uh, aside from whatever laws govern public actions in New York, we're all protected by the First Amendment, at least for the time being. Um, and under that, the government can't prohibit political speech or assembly in public spaces. They cannot outlaw people gathering or speaking in public places like the street, the sidewalk, parks, plazas. However, the government can put rules on the time, place, and manner of speech. For example, limiting sound volume or the use of amplifying equipment, limiting the size of physical displays like signs or mock-ups, um, requiring permits for spaces that are in high demand, like parks, or prohibiting actions that impede traffic or negatively impact around them. So those are all rules that have nothing to do with the content of what we say, what our point is. The government cannot pass rules that regulate the content of what we say, but they can regulate things like how loudly we say it, how we use the space, whether we block other people's movements, etc. And New York City has several such rules. Okay. So in New York City, there is no permit required to gather and demonstrate on a sidewalk, as long as no amplified sound is used, so no bullhorn or microphone, right? There's no limit on the number of people who can gather. There's no limit on what you can say when you gather. And a lot of the times, if you have a protest on the sidewalk, the police will show up and ask to see your permit. But that's a bluff. They know you don't need a permit. They're hoping you don't know that you don't need a permit. Um, and so, yes, but the gathering on the sidewalk must not block other people from using the sidewalk. So this is one of the reasons that we often will form a picket line that keeps moving, or we'll have a space in between the speakers and the rest of us so that people can walk through, right? Okay. A permit is required if you want to march in the street and you are hoping for more than 50 people. Okay. So in New York City, a parade is what they call any kind of action in the street that has 50 or more people, or vehicles, or bicycles, or horses. And so parades require a permit. Um, And the city reserves the right to refuse permits if it's a street that's especially busy or at an especially busy time of day. Again, they cannot base this on what you're demonstrating for. They can't base it on what you're going to say or what you look like. They can only base their refusal to give a permit on um, facts showing that, for example, you're doing this on Broadway at rush hour, and that's a time when the city can't afford it because it'll hold up traffic. Okay. So again, you do not need a permit to protest on the sidewalk as long as you don't use amplified sound. We do need permits to do a march in the street with 50 or more people. In parks and squares and plazas, they tend to be under the Parks Department. And for New York City, to hold an action of more than 20 people in any of those spaces, or to use amplified sound, or to put up a sign bigger than 2 feet by 3 feet, you need to get a permit from the Parks Department. And the reason for that is that these are much in-demand spaces. And so to avoid there being conflicting groups who are, fighting over trying to use the limited space at the same time, the Parks Department can constitutionally set up a permit system. You're supposed to apply for a permit at least 5 days in advance, but uh, if you have to apply less than 5 days in advance, the Parks Department still has to make an effort to grant the permit or process the permit if feasible, right? So they can't make the 5 days just an arbitrary rule. The only reason they can refuse to process a permit is that they really legitimately don't have time to. any gathering in a park or a square or a plaza with 20 or fewer people that doesn't use amplified sound and you're not putting anything up larger than a sign you could carry does not need a permit. And again, as we said before, the fact that sorry, one second, my computer, there we go. Um, uh, the fact that the laws say that we need permits for certain things doesn't necessarily mean that people who need to make themselves heard are always going to get a permit. Sometimes there are reasons why groups can't get a permit. They don't want to alert the police or the parks department to the fact that they're doing it, or it's something that comes together very quickly or spontaneously. Um, and in those cases, there is increased risk of law enforcement coming in, and again, that is a decision that people who are organizing make all the time. We're always making decisions about what risks to take. Uh, we just want to make sure that everybody has all the facts so that you can always make informed decisions about what risks you're taking. Under the First Amendment, there cannot be a permit required to hand out information like flyers or leaflets as long as it's non-commercial and as long as you're not harassing or impeding people. So as long as you're not blocking people from being able to get by you or getting threatening or insulting, or following people. In New York, there is a law against stepping out into the street to hand materials to drivers because they don't want people to get hit or to cause car crashes. But again, if you're ever handing out flyers or any kind of material on a public street or a sidewalk or in the park or anything, and somebody comes up to you and says, "Where's your permit?" You don't need a permit. You have a First Amendment right to hand out any material you want, anytime you want, without anybody's permission. However, posting flyers, putting them up, can get you into some trouble. So it's illegal in New York City to put posters or flyers on public structures, right? Like telephone poles or fences, unless they're specifically designated for that use, like it's a public bulletin board. And not only that, but some organizers a few years ago found out the hard way that if your organization's poster shows up on a public structure, the city will assume that whatever group's name is on that flyer is responsible for putting that flyer up, even if it wasn't you, even if you just handed out flyers and somebody who took it stuck it up on the fence. And the Department of Sanitation, which oversees things like those public structures, even has the power to subpoena the phone company to see what person is behind the phone number on the flyer. And we worked with an organizer and an organization in Queens that uh, was shocked to realize that their Gmail had been subpoenaed, and that Google was going to give their private information to the Department of Sanitation. Um, so you want to be really careful about putting flyers up on any structure that's not set aside for it. So government buildings are public property, and so the First Amendment does operate there, but they're treated differently under the law from streets and sidewalks and parks. They're not automatically open to the public use, as you can find out very quickly if, for example, you tried to walk into the Oval Office. The government can make different rules for each building, right, about who can enter and what you can do inside. Um, Again, they can't Those rules can't be about the content of what you say. They can't say you can go into City Hall and talk to people as long as you're saying nice things about the mayor, but not if you're criticizing the mayor. They can make rules saying, you can't make noise in this part of the building, or there's a limit on the number of people who can gather in this part of the building, or you can't do the following things because they'll interfere with government processes that are going on inside there. So before doing an action in a government building, you always want to check the rules for that specific agency in that building. And they should be publicly available. Okay. So now we're going to talk about actions that take place on private property, right? Like in your building, in a landlord's office or in an office building, in a store, in a restaurant, or another business. So often you may hear somebody say, "Hey, you're trespassing if because you set foot in this building and I didn't tell you you could." Or you walked up to the front of a building and you rang the bell. That's not correct. Um, the law of trespassing includes a rule that certain places, even though they're private property, are presumably open to the public, right? You have a standing invitation to go in there, like a store or a restaurant, or the lobby of an office building, or the front stoop of a building that you need to step up on in order to ring the bell, right? And we know this because we're not charged with trespassing every time we go to the store without getting permission first, right? So all of those areas, all of those public parts of private property are open to us. We can go into them without getting permission first. However, if the owner or somebody in control of that space, like a manager or a superintendent or a security guard, expressly tells us to leave, then it becomes trespassing if we don't. Right. So again, there's presumed to be an open and standing invitation for us to go into public facilities like stores and restaurants and lobbies. Uh, but the owner or anyone who controls it can revoke that standing invitation. They can say, you, Grinthal, you're not welcome in here anymore, right? And then if I stay or if I come back, what I'm doing could legally be called trespassing. Uh, Trespassing also is not entering any private property with permission for someone who has the right to use that property. So most often, as tenants, we can give our visitors permission to come into our buildings. And our landlord cannot say no, you're not allowed to have guests, right? Being a tenant of an apartment includes the right to decide who can come visit you, right? And that includes the use of the public parts of the building, like the lobby and the hallway that people have to pass through in order to get to your apartment. Right? So, practically speaking, this means that for an organizer like Anna or Jonathan, to go into a building and knock on doors to try to talk to tenants, that might be trespassing if they do it without anybody's permission. But if there's a tenant in the building who says, I'd like you to come and door knock with me to talk to my neighbors, then it is not trespassing because the tenant has the authority to say who can come and visit them and who can't. And again, knocking on people's doors, ringing their bells is not trespassing, nor is it harassment, unless they specifically ask you not to do it. Okay. So those are the laws that are about limiting what we can do without breaking the law. But we also have laws that expand what we can do. We have laws that protect what we can do. And most importantly, in New York, we have real property law section 230. That's a state law, and it recognizes tenants' rights to organize. Specifically, what it says is tenants have the right to form tenant associations. Tenants have the right to door knock and hand out flyers in their building. Tenants have the right to use common areas of the building for meetings, like hallways and lobbies, as long as you're not blocking the way or doing something dangerous, right? The law also says that landlords cannot retaliate against tenants for doing any of these things. Right? Real Property Law 230 was passed in 1970 after an assembly member from the Bronx was visiting a tenant association meeting in his district. The landlord called the police, said they were all trespassing, and the assembly member was arrested for trespassing. The next morning, he got out of jail and went straight to his office and introduced a bill. And so we have Real Property Law 230 that says we can't be arrested for holding meetings in the lobby of a building. So that means landlords cannot interfere with our rights to form, organize, or participate in any group that is intended to protect the rights of tenants, right? So that's how the law defines a tenant association. That means that landlords or their employees can't tell you not to form tenant associations. They can't tell you not to go to the meeting. They can't tell you not to participate in the tenant association. They also can't withhold or revoke any of your rights or privileges to deter you from participating in a tenants association. And that can include things like saying, I'll take extra special care of you if you don't participate in the tenant association. Or, if you're going to go with those people, then I'm not going to do repairs for you anymore, or I'm not going to renew your lease, right? All of that is a violation of Real Property Law 230. The laws on handing out flyers or flyering in the building can get a little fine-grained. Um, Landlords can prohibit us from putting flyers on the walls or the doors in the common areas of the building. But they cannot prevent tenants from door knocking, handing out flyers. They can't prevent tenants from slipping flyers under people's doors. Uh, Landlords can deny tenants the ability to hang flyers or signs out of their windows or on the outside of the building, since those parts of the building are under the landlord's control, right? But we can put signs in our windows as long as we post them on the insides of our windows. And again, when I say can and can't, that is not to say what we necessarily can and can't do, just what the law says. First of all, very often, in reality, it's very hard to do things that the law says we can do. And when a landlord says to us, I'm going to retaliate against you for participating, it's all well and good that we have Real Property Law 230, but it's not going to step in and protect us in the moment. In order to make sure that we actually have our rights, it's important, first of all, for us to form groups. Even though a landlord might threaten you with retaliation for joining a group makes it harder for them to retaliate against you because there's power in numbers. Okay? And if you get into a sticky situation or you have a question about what does the law say in a particular situation, that's what we're here for as lawyers. And you and Cooper Square Committee can reach out to us and we can sit down together and talk about what the situation is and what the law says and how you might be able to use it, how it might get in your way. meeting in the building, again, under real property law 230, landlords can't deny you the use of space for tenant associations, right? So for most of our buildings, common areas means the lobby, the hallways, the stairwells, right? If the building has a rec room or a community room, you have the right to meet in there. And even if there would normally be a fee for using that room, like let's say if you wanted to hold a birthday party, that fee must be waived for a tenant association meeting. And that's, again, real property law 230. Uh, However, in order to qualify under the law as a tenant association meeting, the meeting has to be open to anyone who lives in the building. It has to be peaceful. It has to be during reasonable hours, right? So if you say, me and my across the hall neighbor are going to hold a tenant association meeting, no one else is invited, real property law 230 does not consider that a tenant association. It has to be open to any tenant who wants to participate in order to get the protection of the law. Sorry, this is what happens when I have 3 or 4 screens open. There we go. So I said retaliation is against the law under real property law 230. What does that mean? I also say there is a separate law that also says that a landlord cannot start an eviction lawsuit or refuse to renew a lease or a tenancy because you participated in a tenants association or because you made a complaint to any city agency or you did anything else to exercise your rights under the lease or under the law. Landlord also can't change the terms of your tenancy, like impose new rules on you or raise your rent in retaliation for participating in a tenants association. The hard thing about this, of course, is that it's very difficult to prove what a landlord's intention was. So a landlord may say, I'm choosing not to renew your lease because I've decided I want to, I just don't feel like renting to you anymore. I want to renovate the apartment. And it can be very hard to prove in court that they actually are doing it in retaliation. Um, so we recommend that when you're having, difficult interactions with the landlord, when the landlord is saying things that might be threatening, or saying there might be consequences, or telling you why they're taking a certain action, make sure to document everything that you can, because if in the end they follow through and you wind up in a situation where you're fighting an eviction in court or you're making a complaint of the DHCR, those notes and recordings and photographs are going to be your evidence, and the strength of your case is going to be in those. And most landlords know the law well enough not to come out and say, I'm not renewing your lease because you participated in a tenant association. Nevertheless, sometimes landlords say things in a moment of anger. Sometimes someone who works for the landlord might not know as much about the law and might spill the beans and, be more honest than the landlord wishes they were. So the best we can do is gather as much information about that as possible, and to share that information between tenants, right? Okay. So that was a lot of me talking. Let's take some time if people have questions and answers, but I'm also interested in people's experiences, even if you don't have a question. Whether anything we've talked about here touches on, something that's happened in your building, where you've, uh, been able to use the law or the law has been used against you.